I'm really excited to be able to cover some of the major elements based upon the questions that we've been receiving via email and phone calls. There's a lot of holes still in the process, but we're getting kind of short on time. So we wanted to cover some of the major points that you're going to need to know relative to this new E&O requirement policy. So in the webinar, we're going to be talking about basically the renewal process and the paperwork with lots of screenshots that you can review to walk right through the process. Elements of the E&O insurance that's affecting you, and then the Alaska statutes and regs that are also having an impact on you. Once we've done that, we'll go ahead and talk about a great savings that we want to offer you for attending the webinar today. And then finally, we'll close with some questions and answers so that we can drill down into some of the questions that you might have. We put together a number of E&O resources, which includes an E&O documentation package that shows the various E&O policies that Rice Insurance is putting forward, as well as some of the other documentation relative to statutes and regs and forms and etc. In addition to that, we put together a 51-page resource package. We'll be sending these out to you. This includes all the slides from this PowerPoint presentation, and then also some resources that have been provided by Rice relative to the types of E&O claims that they are most frequently seeing. So the question is, why am I teaching this class? Many of you know that I've been teaching for a number of years, both the risk management and E&O insurance. In addition to that, I've been teaching asset protection for 11 years, teaching in 46 states and 5 countries. I've now mapped up a total of 35 expert witness cases, so I can tell you firsthand about some of the challenges that we face as an industry. And of course, we do both our Maui conference, but in addition to that, we have also started doing conferences here in Alaska as well. In fact, the special package that we're offering also includes your ability to attend the conference, the EDGE conference here in Anchorage in July, or rather that's June. So getting into the meat of the matter, data needed for your online renewal. If you're going to go online, there are certain numbers that you should collect before you go through that process, or you're going to be jumping all over the place. You could even use this form to write the numbers down. If you're a licensee, you're going to need to know what your real estate license number is. My own is 11255, but when you go to renew, you also have to put in front of the license number REC for the Real Estate Commission. Because I'm a broker, I put B and then the 11255. Otherwise, it won't recognize the number and it won't let you move forward with the online registration. So you got to get your real estate license number. Also, as a part of the process for licensees, you also have to identify your business license number. So if you haven't got that, you're going to have to do that before you're going to be able to move forward with your online renewal. In addition to that, brokers need some additional information. They need to know their entity number and also the trust account bank number and the account number. So that information is also, there are links provided in the licensee renewal E&O resources compilation. So all the links to these specific pages to get to these specific different sections of the state website in order for you to be able to retrieve that information are there very easily for you. You can click on the active links and walk right through the process. We have, here's an example of the renewal resource links. You see up above here the various links to the state websites to look up your entity and your license number and your business license number. There's also a number of other links that are included on that page that take you right to the specific pages, some of which we've talked about and we'll talk about in this webinar. So when you go to the online renewal, you'll see, as an example, I've identified an active link here up on top. You can just click on that either through the pages of the PowerPoint, which are included in your compilation, or you can click on the resource link page. So you go to click here to renew your license if you're looking for renewal instructions. That's basically this general information that talks about how long it takes them to do it manually. Of course, the license term is January 31st to the 31st. And then it also identifies the E&O requirements that are now necessary. And of course, the yes responses. These are those 5 questions that they typically ask. Have you murdered anybody lately? Are the police looking for you right now? If you can say no to all of those questions, then you can go ahead and move forward through the online renewal process. So again, you've got to make sure you get your business license. Unless you are an employee and are not getting 1099 wages, then that would not be necessary. So here you'll see the example where I've gotten my license number, and as I mentioned, you have to add those letters before it in order for it to be able to retrieve your record. And in addition, if you need to look up your entity number, this is the link up above to be able to look that information up. That's primarily for brokers. If you have to go for your business license search, you can click on this link above. It's an active link. Whether you're a broker or a licensee, you need to provide your business license number. And then in addition to that, here you'll see where I've actually looked up my own real estate broker's license through the link up here to be able to search for your professional license. So those are all the various links. My recommendation is you write those numbers down so that you don't have to be jumping in and out or opening up additional windows when you're walking through the registration process. Once you've done the renewal, what you will find that's different from years in the past is historically, once I did the online renewal, it automatically then verified and extended the expiration date. That's no longer the case. What happens now is there's a little pop-up that tells you that your renewal is not going to be complete unless all the required documents have been verified by the real estate commission. So if you're using the Rice Insurance, they send that information over to them. Otherwise, you have to send over your certificate of insurance. Otherwise, they will not process that application. Now, a new thing that they just came up with right after Christmas was the ability for brokers to send an entire list of their licensees if they are a large company. It's been a modification and a change that happened really over the weekend and the latter part of last week when some of the larger brokerages started experiencing the difficulty of being able to get that documentation in. So the Real Estate Commission changed their interpretation of what was necessary. But if you're at a smaller company, you need to get that certificate of insurance. I'm also going to address a little bit later the form that they will now accept based upon the fact they had problems having independent insurance companies sign the acknowledgement that they were looking for because of some of the language. Now, there is another form that can be used in its place. Both of those forms are found in the resource compilation that we're sending to you. So comes back and it lets me know that my license has not been extended. In fact, we will be waiting for the review from the Real Estate Commission of the insurance, in this case, because I did purchase the Rice Insurance. Not expecting any kind of a challenge, but it just wasn't automated as quickly as it has been in the past because of that new requirement. Now, this was the wrong affidavit that's currently being linked off the Real Estate Commission website, because when you go to print the renewal package out, if you were going to send it in manually, this is the document that shows up, but this is not the document that we need. The application of this document is specifically if a large company or somebody has greater than a $5,000 deductible, then they have to show that they have certain financial resources and affirm that in this affidavit. The real documents that you need to show that you have real estate E&O coverage, if you're doing this on something other than the Rice, are shown here. To the left, you see the original errors and omissions certification of coverage that had been used by the Real Estate Commission, but because of some of the structure of these questions, they modified their approach based upon a number of complaints that were coming in to be able to use the Accord Certificate of Liability Insurance. Accord is an organization of insurance professionals that gives some standardized forms that they're more comfortable with. And so now the requirement has been modified so that either the certificate of coverage, which had originally been used, can be used, or this Accord document, Accord 25, they call it, which insurance carriers are less reluctant to sign because it's a form that they're more accustomed to using. If you go to the Rice Insurance Services Company, or RISC as it's referred to, if you come, this is their front page. It gives you some generic information. Then once you start the renewal process, you can then click on the various buttons. I'm just showing you how this thing follows through. They talk about some of the features, and you set up an account and walk through the process, answering the specific questions that enable you to be able to identify whether or not the $450 policy or the $642 policy is the one that you can use. It really seems like they're pushing you through the more expensive policy, because one of the questions that they ask is, have you ever sold anything larger than a duplex? Even though it seems to me that that shouldn't be relevant, given that they are not going to be providing insurance. If I sold a triplex 10 years ago, I don't understand why that should impact the rate of insurance that I'm currently paying and bumping it up from the $450 price point to the $642. So we'll have to take a real close look once these renewals and insurance all come in, as we monitor and track how many were they able to kind of push into the more expensive package based upon the sale of real estate or management of real estate at any time in the past in your entire career, even though they're not going to cover it anyway. So it seems to me a little outside the lines, if you will, not necessarily from the best interest of reasonable insurance to cover our acts once a policy goes into effect, but it seems to be more of a move to try to get us to feel somewhat intimidated to buy the more expensive insurance product. So I think this needs to be, certainly not now because time is so short, but as time goes on and we start reassessing how many claims versus how much money was collected, to see whether or not this solution that was brought forward by Organized Real Estate was for a problem that didn't really exist. And because there's a lot of people that feel that this was really a move to put smaller companies out of business to push people towards larger companies. So we'll see moving forward. It is what it is. And right now, most people are more concerned about making sure that they don't have their license lapse because of lack of insurance. We'll have to come back and do some reviews and assessments later. Then these are the various, as you move through the screens through Rice Insurance, it identifies the policy coverage, gets into what excludes you from being able to use the less expensive policy. All of the entire policy is in the handouts that we've sent to you and that you can download, because some of the other things that we can do, if we're only doing residential, we can add coverage options that would cover any residential duplexes and below that we personally own. However, in reviewing through multiple classes, the observation of most of the people that are involved in managing their own commercial properties are that nothing that they do for their own property is going to be covered if it's commercial or anything duplex and above. It also gets into, have you had any claims, what the process looks like. You put in your email, your personal information, and then review it. So it's a fairly simple 9-step process that you walk through, and then your insurance is available immediately to help you comply, because as you go through the online renewal, what I found was that the question of do you have E&O insurance forced me to go to the Rice site and sign up for the insurance so that I could move forward with my online renewal. So this kind of had to be done first before I was able to renew my license. In addition to that, there are some other sources of information. Here you see the Rice site, the resources in their FAQ. They have some articles that relate to education and risk management. And then their FAQ section is fairly extensive. You can get into clicking on these various links to drive down a little bit more into more detail on each of those specific areas. The FAQ section on the Real Estate Commission, we will also take a look at It's much lighter. There's only a few questions that are actually answered. And then at the end of the webinar tonight, we'll also be looking for any questions that you may have. So hold your questions until the end and then type them into the chat box, and we'll be able to address those questions as well. So the Real Estate Commission's E&O section, this is the URL up above here that gets you here. There are a number of different documents and forms. We're going to take a look at their insurance FAQs because it's fairly light. A lot of these earlier documents and links really relate to the process as we've been going through this. Presentations from Rice and Associates down in the bottom back in July. A short information sheet from Rice Insurance Services that at this point probably is not real valuable. And then we get into the various regulations, which are also included in your downloads so that you can look specifically at them. You can also look at the policy itself that Rice is providing so that you can see the specific exclusions of things that they do not cover. We know that having E&O is a good idea. A lot of lawsuits that are happening now are based on employment lawsuits with less than 100 employees. And these can be very expensive to resolve. Unfortunately, employment lawsuits are typically not covered under the E&O policy exclusions in the Rice policy. The average business, 4 out of 12 have been sued in the last 5 years, and the average real estate professional is sued 5 to 7 times in their career. So the need for E&O insurance for a lot of these folks is something that was decided by some of the larger brokerages that pushed this thing forward. Many people felt it was unnecessary and felt that some of the types of real estate practice that the industry is involved in, like property management, association management, certain types of commercial consulting, things like that, they're not covered at all. And so for a lot of people, the insurance is relatively worthless because it doesn't apply to the types of businesses that they actually practice. Cost to litigate has gone up to $54,000 on average. So one of the things that's nice about the Rice policy is the limits do not include the litigation costs. There is no deductible on the litigation costs, according to my interpretation of the policy. It's only the damages that we have to deal with in terms of the maximum. The United States, with 4% of the world's population, is responsible for 94% of all lawsuits. So we like to sue people here. So having some errors in emission insurance can protect you and potentially give consumers some recourse should something go wrong on the transaction. If the licensee does not have the funds to be able to remedy the situation, then the argument is that the E&O, under a lot of the provisions of work that we generally do, are going to cover the problem, with the exception of the exclusions that can be found in the policy for Rice and Associates, Rice Insurance, which is in the 2 documents that we'll be sending you relative to the resources. So in looking at errors and omissions insurance, it's kind of like medical malpractice. They both cover professional liability and deal with negligent acts or failure by the state licensed specialists with specific skills and training to step up to the level that should be expected and thus protect the consumers against acts that they would otherwise not have any recourse for. It's designed to protect the professionals from financial consequence of claims brought by consumers, and the issue of whether or not, if the licensee did not have funding, would the consumer be damaged because there was no way to protect them. E&O could be argued does that for them. So even when those services are performed with the utmost skill, sometimes they're not happy with the outcome. Sometimes it seems like the harder you work, the more upset the consumer is. So E&O is designed to protect the real estate professional and consumers from financial losses in such a suit. And that once the insurer is notified of the claim, insurance company has to step in and defend the claim, as well as paying any settlement or judgment against the insured professionals. In fact, as soon as you hear any threat whatsoever of a claim, you're required to notify as quickly as possible the E&O carrier. If you don't do that, they could reject your claim and you may not be covered. So you need to get them into the loop as quickly as possible. In addition to that, it's there to cover our liability if we just make a mistake. Doesn't make us evil. Sometimes mistakes happen no matter how hard we've tried. Sometimes it will step in when someone has dropped the ball. Remember that whenever we're involved in a real estate transaction, in the eyes of the court, that's seen as a general partnership. And because we've adopted the Uniform General Partnership Act, jointly and severally liable means they can come after anybody involved in the transaction for the entire amount of the loss, whether that person was directly responsible or not. So it could be something inadvertently neglected. Somebody forgot to do something that they should have done, and as a result, there are damages. And it could be whether it's pursuant to a rule or custom, what is standard, what is customary, in our particular area. So that future alone can save a licensee, both firm and individual, of thousands, if not tens of thousands of dollars in legal defense fees you might have to otherwise incur to defend a lawsuit, because litigation is expensive. Now, when we look at E&O insurance policies, they can basically be written for virtually any type of company, from one-person sole proprietorships to large 500 licensee, or in some cases corporate as many as 20,000 or more. Often you find at larger companies they are based on different criteria than the blanket policy, and so very often companies that are dealing with referral services see that that part of their business does not increase their errors and omissions insurance costs because there's not a lot of performance coming out of that part of their company. So E&O insurance, typically the named insured is the company, although in this case, the real estate commission will be the named insured for the policy level, then we're covered underneath that. So it extends coverage to current employees and independent contractors associated with the company. If we're getting the RICE insurance, that also extends to some of the activities that are being performed by the unlicensed assistants that may be under the umbrella of the person with the coverage. So their personal assistants, former employees, independent contractors, or personal assistants possibly could be covered if they're named in the claim. It depends on whether or not they're still at the company or if they have bought the extended coverage. So it sort of depends on what kind of policy you're getting. When you're looking at these E&O insurance, the policies can vary. So it's important to compare the state requirements, which are in your downloads, against the individual policies that you may have. Some real estate brokers have faced difficulties because of the requirement in the regulation of OC licensing that requires that licensees must agree before any settlement is reached. However, the way that RICE insurance basically covered their downside in that was they put provisions in their policy that said, yes, they can't settle a claim without the licensee's permission, which will not be unreasonably withheld. But the language that was approved by the Division of Insurance included language that said, oh, by the way, if the licensee will not settle the claim, let's say it's a $1,200 claim and they're going to take it to the Supreme Court thinking somebody else is going to pay their legal expenses, the language in the RICE insurance company policy from CNA or Continental Insurance was that should the licensee choose to move forward and litigate and not settle, then the coverage from the insurance carrier is limited only to the amount that it would have taken to settle the claim. Any additional cost, expense, litigation, etc., is the responsibility of the licensee. So while a lot of insurance companies have balked at that, we know now that there's language that address that in the insurance policy that was approved by the Division of Insurance. So that may be a strategy if you're finding that your insurance carrier was really reluctant to sign the coverage of insurance. Now they can sign the Accord 25. And if they say we don't like this provision that lets the licensee decide to litigate, you can show them the section of the RICE insurance policy that was submitted that shows specifically how they have addressed the downside and still retain the ability for the licensee to decide to settle, but anything above the settlement cost at that point are going to be at the expense of the licensee. So licensees should review and become familiar with the terms of their particular coverage to determine whether or not it really is going to cover them, whether the brokerage is buying it or they themselves are buying it. Virtually all E&O policies provide coverage on a claims-made basis rather than on an occurrence basis. So what do we mean by that? When we're looking at occurrence-based policies, examples of those include automobile insurance, homeowners insurance, or an insurer whose policy is in effect at the time the event occurred or occurrence. Insurer is liable under the policy even if the claim is not made until 2 or 3 years after the event. However, on a claims-based policy, which is typically the type of policy that E&O is going to be, including ours, then it covers any claims that arise or are filed during the policy period. Even if the underlying event happened several years earlier, it's when did the claim come in. Now, on a claims-made policy, it includes a retroactive date, often referred to as a prior acts date. So it bars any liability of the insured to defend against or pay claims arising from events which occurred prior to the retroactive date. So in the earlier slide it said, well, it could happen 2 years ago. However, if the insurance was not in place at that time and it was before the retroactive date, the insurance carrier is not going to cover it. So E&O claims, let's say an individual broker decides to convert from a sole proprietorship to an LLC. They name the company Risk Realty. So the company begins doing business on May 1st, 2005 and obtains E&O insurance through You Are Safe E&O, which it renews each year thereafter through March 15th, 2016. So the retroactive date of the policy is May 1st, 2005 because they've maintained the policy current throughout all of those 11 years. So the retroactive date is how far back does your coverage extends. It goes back to the original retroactive or effective date of your original policy if you maintain continuous coverage, but it can reset if you let the coverage lapse and may be expensive, sometimes impossible to establish the original retroactive date if it does reset. So here's an example. We see the retroactive date of May 1st, 2005. Risk Realty opens up. You Are Safe E&O coverage begins. So You Are Safe E&O is covering the policy and up until the point of March 15th, 2016, when Risk Realty cancels the You Are Safe E&O policy. So given this example, the coverage ends from the You Are Safe E&O carrier on March 15th, 2016. So all during the period of time between the retroactive date and the end of the coverage, any events that occurred would be covered with this policy. So Risk Realty is covered by You Are Safe E&O during that period of time. However, there is no grace period typically, so it's critical that licensees or brokers timely pay their insurance premium because unlike homeowners and automobile insurance policies, which may allow a grace period to reinstate a policy, generally E&O policies do not. So they're looking for a reason to deny your claim. So if in the foregoing scenario, assume the company failed to timely renew its policy in February of 2008 and was not allowed any grace period to reinstate. It then obtained a new policy with an issue date of February 25th, 2008. However, the retroactive date is no longer May 2015, but rather February 25th, 2008. So the effective date of the current policy has created a lapse in coverage. Of course, the significance is that no claim that arose prior to February 25th, 2008 will be covered under the current policy, although it's a claims-made basis. So the retroactive date absolves an insurer from liability for any claim made during the policy period for an event that occurred prior to the retroactive date. So here's an example of what we're talking about here, where the original coverage was May 1st, 2005. However, we had a payment which caused the coverage to lapse with a new retroactive date of February 25th, 2008. So that means that if an incident occurred where the star occurred, you wouldn't be covered under that. The retroactive date will be the date on which an insurer first began providing insurance. So if the company transfers its policy from one insurer to the other, what you want to try to do is obtain a policy that has the same retroactive date as the policy that's being relinquished. Otherwise, you could have an interruption in your policy and you may have a claim then that is not covered. So March 25th, 2016, company decided to switch its E&O policy to no stress E&O. Typically, the retroactive date on the no stress E&O policy would be the date they first issued coverage, i.e. April 1st, 2016. So if a claim is made on June 1st, 2016 regarding an event on March 20th, the current insurer would not be liable under the policy because the event occurred prior to the retroactive or prior acts dates. It's real important to get those dates into alignment. So if that were to happen, the company would no longer have any insurance coverage claims for claims which occurred prior to April 1, 2016, as no stress E&O would not be liable for any claims occurring prior to the retroactive date, and the company would have terminated its company with You Are Safe. So we've got to make sure that there is not that kind of situation. So here we see Risk Realty originally opens up. They misses their payment in February 25th of 08. They then cancel You Are Safe coverage on the 15th of March and then initiate a new policy April 1st, 2016 with no stress E&O. So we're going to have some periods here where we have a lapse in service. So as an example, in this arrow, were an event to occur, it wouldn't be covered. So if you want to ensure continuous coverage, company wants to negotiate a retroactive date in alignment with the new policy date. So what retroactive date may be used could be a point of negotiation between the real estate company and the new insurance company. Sometimes it's based on how large the company is. So what kind of revenue do they expect to earn from your business? That can have an impact on it. So other things that we'll also take a look at is other considerations in extended insurance, particularly the number of past claims. Unlike the Rice insurance, it was basically flying blind with no payment or claim history. Now the requirement is that they report to the real estate commission on a quarterly basis any claims that have been made. If you want to be covered in a transaction that you feel something was going wrong on the other side, the only way that you can be covered based upon the policy that they've identified and the stipulations is that you have to report the other licensee to the real estate commission if they're doing something wrong, and you want to make sure that your E&O is covering you in that same transaction. There is now a requirement that we report their actions to the real estate commission, which some people have a real problem with. They feel that we're being made the police of the industry based upon this new policy stipulation. So if you've been in business for 20 years, it may not be necessary that a new policy's retroactive date actually go back the entire 20 years. You may feel that 10 years may be more than sufficient in order to not pay too much to get the coverage that you're going to need. So you really need to assess your liability, consider the applicable statutes of limitations, since basically you're buying insurance to cover lawsuits, and then from that negotiate an acceptable retroactive date. So in terms of bridging the gap, if you can't obtain a new policy with an acceptable retroactive date, then another option is to secure the new policy, but also pay for an extension or endorsement of the existing policy, such that it will be continuing to provide coverage for any claims arriving from its retroactive date through a stated date. The Rice insurance and state regulatory requirements were that they do allow the licensee to buy additional years of coverage. If, let's say, you decide to let your license lapse, they have a cost that you can pay for up to 5 years of coverage if you're going to let your license lapse. Similarly, if you're applied to the earlier example, the new policy could be through no stress E&O with both an effective and retroactive date of April 1st, 2016. Then the company pays for a 3-year extension of its policy with You Are Safe, which would cover any claims filed between May 1st, 2005 and March 15th, 2016 relating to transactions handled by the company between May 1st, 2005 through April 15th, 2016. Now, keep in mind that maybe we're moving fairly fast on this, but we are going to be sending you out a link to the replay so you can slow it down, cover some of this stuff a little bit more slowly in order for it to kind of sink in if that's going to be helpful. So after closing the brokerage, it may be a good idea to consider, this happened to a friend of mine up in Fairbanks. He was looking at closing his brokerage, but there was a potential claim that had arisen. So just to be on the safe side, he decided to go ahead and pay for that additional coverage. And 2 weeks after he did that, the lawsuit came in. So sometimes it could be a fairly minor cost that can save you a tremendous amount of money should something happen after you've decided to close the brokerage doors or you've decided to leave the real estate profession. So don't drop the insurance just because you've closed the door, because you may think you don't no longer need the coverage, but sometimes lawsuits can show up. And if you decided, let's say, to extend that coverage an extra year, 8 months later, if a lawsuit occurs regarding a transaction that occurred 18 months prior to the company closing, you could still be covered. Some insurers offer policy extensions of endorsement 1, 2, 3, 4, or even an unlimited term. The current Rice policy required that they offered up to 5 years. However, it's expensive and it has to be paid up front in order to be able to get it. So where do the claims come from? E&O policies only cover negligent rather than intentional acts. And there are a number of sections in the Continental Insurance policy that Rice has gotten approved that get into the specific exclusions and the definitions of those particular acts. So one will not usually see claims relating to trust account matters, particularly theft, because that's an intentional or criminal act and it's not going to be covered under the policy. In addition to that, where do most of the claims come from? The majority relate to misrepresentation issues. So they could be either affirmative statements, you said the roof was good when it really wasn't, or failure to disclose when there's a duty to disclose things that you know about the property. And in looking at those exclusions, you see that the Rice insurance policy really does require a pretty heightened level of diligence from the licensee, even one that could be seen as potentially inconsistent with our laws as licensees, because we're not required to investigate matters beyond the scope of our expertise. But on close reading of the Rice policy, it appears that they're holding us to a higher standard in some cases, as opposed to what the state licensee requirements are. So good to take a look at that to understand it. The insurer reported a total of 264 claims handled between January 2015, July 2016. 149 of those claims related to misrepresentation issue, and then 13 claims from failure to disclose facts about or related to the property. So it's important to give full disclosure of property condition. That's why we developed the 3470 form to begin with. 61% of the claims involved misrepresentation, mostly from disgruntled buyers unhappy with the property condition. Some of those include foundation or structural problem complaints, drainage or other water issues, and restrictive covenants or zoning matters. So making sure that those 3470 forms are filled out completely by the seller is a way of minimizing your exposure. The residential type of Rice insurance is only available for duplexes and below, which is also the criteria of the 3470 real property transfer disclosure form. So really trying to get those things filled out is important to happen. So E&O misrepresentations claims, examples of some of those common ones include things like advertising a property as having access to public sewers. In fact, it's got a private septic system. Could also be water intrusion, faulty foundations, roofs or windows, inferior design or construction, which can lead to wood, dry rot, mold, and pest infestations. You know, with the type of properties that we have to show in the winter times, sometimes it's difficult to really be able to pin down the property condition. So we have to be extremely careful in making sure that we don't misrepresent the property condition, because there's sometimes you just can't really look at it visually to tell. In addition to that, common misrepresentation includes the misidentification of boundary lines or actually selling the wrong lot. So we don't want to tell the buyer exactly where the lot lines are. We can say that the lot lines appear to be along the fence line, but only a survey can really tell for sure. I'm dealing with one of our students right now who has had somebody intruding into their space and is now actually trying to argue that the person who has been doing the trespassing is now claiming that they have a prescriptive easement similar to an adverse possession claim. So we really need to keep an eye on our property to see if anybody's starting to move a bunch of junk into our property. We want to be able to get it out of there before they establish some sort of rights. So failure to disclose the true extent of any pest infestation, although it's not typically a real big issue that we have to worry about here, or misrepresenting the schools which are in the district. Those could also lead to a claim if they had their heart set on a particular school district. So make sure you know what you're talking about. Don't make representations you're not sure of. And when in doubt, don't hesitate to say, I'm not sure. Let me check on that for you if that's something that is important to you, so that we don't make bad mistakes by making misrepresentations. So misrepresenting the amount of property taxes, let them look it up themselves, or the well water pressure quality, that's outside the scope of our expertise. It's not our job to know that, so we shouldn't be making those kinds of representations. Or failing to disclose zoning or restrictive covenant limitations. It may not hurt to look at that. Some would argue, as a licensee, I don't have to. I know in one case where a transaction where they did not review some of the limitations in the resale certificate, it led to a lawsuit that included over $300,000 worth of damages. So taking a look at those resale certificates, while you could argue technically it's not required, you might want to do it anyways. Failure to disclose latent defects such as radon, lead-based paint, and asbestos. These are areas that the Rice insurance policy really drills down to much more deeply than licensee duties might suggest we're required to do. So it's important to read that policy if you're going with the Rice Insurance Company, and if not, take a very close look at a policy if you're going to be using an alternative carrier. Read the policy. Feel free to ask us, send us any questions that you have to make sure that you're actually being covered. You don't want to be get into a bad surprise. So misrepresentation of claims can also include failing to determine, disclose the capacity with which a licensee will work with the consumer, i.e., did you get the AREC signed? What about neutral licensees? Did you breach any of those duties? You've got some exposure. If that were to occur, probably 10% of the claims face these kinds of issues. Fair housing violations, not covered at all in your errors and omissions insurance. There is a small cap on those, but typically these violations can run into the tens of thousands of dollars, and the Rice Insurance has limited themselves to $5,000 or $10,000 when it's relating to discrimination or when we're dealing with environmental contamination claims. So ADA claims can also be brought against if you're not doing reasonably, making an effort to try to make buildings accessible. So you've got to make sure that you've got ramps, curb breaks, and et cetera, to make sure that anybody can access the property. Antitrust is another source of E&O claims, but including price fixing and group boycotts. These will not be covered by the Rice insurance policy, which is common. Unauthorized practice of law, not covered. Environmental liability has a very, very narrow limitation that won't even come close to covering the environmental issues on the property. So I think it's $5,000 is a maximum, whereas environmental liability could end up in the hundreds of thousands of dollars. Any RESPA violations, giving referral fees or unearned fees, those are illegal, and they would not be covered under the E&O policy. So insurance companies assess their risk when you're looking at getting something underwritten. They'll look at different types of, some cases, the coverage is based on frequency versus severity. So in looking at that stipulation, high frequency, lots of claims filed, claims typically not terribly high, thus the risk liability is lower. Residential brokerage would often fall into this high frequency category. Whereas severity of claims, we may not have as many claims, but the average cost is substantially higher. This would be the kinds of things that we might find under commercial brokerage that has a much higher amount of claim should a mistake happen because of the nature of those claims. And then E&O underwriters are going to consider a lot of factors to determine the extent of any coverage it's willing to extend. Those factors can include the type of activity, how many years have you been engaged, how many licensees do you have underneath you, what is their average time that they've been licensed, how many complaints or lawsuits have been brought against the company or its associates over the last several years. Because in the case of the Rice Insurance, they had no historical claim data from which to base their policy limits on. If you're going outside of the mandatory group insurance, then they're going to be looking at reasonable business considerations when they're deciding what they're going to charge you for your policy. That is not the case with Rice Insurance. A person that's in a referral company that did one transaction in the last 3 years is going to pay the same price as somebody that did 200 transactions last year. So until there's some claims history, they're just kind of poking in the dark when they came up with these numbers. So maybe we can go back and revisit them once we've actually got some history to try to make a move to try to reduce the policy down the road, but that's not something that's going to happen anytime real soon. So how long the company has been in existence, whether there are written office policies at the brokerage and procedures, the law requires that that be there. But insurance carriers can look at that as well. Whether the procedures are actually followed is a plus. What about internal supervision and office management? Because it's believed that if we're going to give good training to the licensees in the office, less liability of insurance claims actually happening. Now, the amount of premiums that have been paid in the past are going to be looked at, numerous other factors that the underwriters are going to be looking at. The policy premium is going to be influenced by the underwriter's assessment of these factors, amongst others, as well as the amount of insurance desired. So insurers are going to assess the facts of each case, the licensee's applicable duty and standard of care in that particular instance. Did you do your job? Did you get it right? The extent to which the licensee met that standard. Were you blatantly in violation, or did you come awfully darn close? What are going to be the costs to defend the action? And in deciding how to approach the case and whether to settle, those things are going to be looked at. And as I mentioned before, they've added stipulation says that they have conformed to the requirement that the regulations had that the licensee gets to decide to settle. But to protect the downside of the insurance carrier, they've added language that was approved by the Division of Insurance. It says if the licensee decides not to settle, then they're going to pay for everything that costs more than the settlement that was offered at the time. So sometimes insurers will settle a case for a relatively low amount, even though the liability is questionable, because it's just not worth the cost to litigate. So will it cost the insurer less to settle than to pay the attorney's fees to defend the action? That can cause them to move forward based on what makes sense from a business perspective. So the less an insurer has to spend on any governing policyholder's account, the less that policyholder's premiums are going to increase. But with this group policy, that is probably not something that's being looked at because they have to offer this to everybody. It will be the industry 1 or 2 years down the road looking at what did we pay and what did they have to pay based on the money that was collected. Because if we as an industry are paying them $1 million a year and the claims are less than 200,000, are there some other alternatives such as self-insurance with a secondary insurance over the top that we could start looking at down the road as a better way to deliver more value both to the real estate industry and to the consumers who it is designed to protect? So some situations, they'll defend the company against claims arising out of your intentional act if the company was not complicit. And again, it depends on if it's a group policy or that offered by the state or individual policy. The associate's defense costs would not be paid under the E&O policy because an intentional act is excluded from the policy coverage. So they might not cover the individual licensee, but they may cover the company under certain circumstances. So if a broker wants protection for its business trust or escrow account, you might require that everyone who has access to the account or handles the money in the office be bonded as a way of limiting your exposure. The company could pay the premium to bond all employees having access to trust account monies as a business expense. That allows us to pass a portion or all the costs for each employee or independent contractor onto each as part of the employment arrangement. Some of the companies are charging on a monthly basis. Some are charging on a per transaction basis. So different payment delivery requirements are being used by different insurance carriers. The Rice Insurance requires that the entire premium be paid up front. So in summary, the licensee should review their brokerage's practice, assess their weaknesses and potential liability, confer with an insurance agent to learn what type of coverage he or she may offer and the estimated premium for the licensee's practice. Discuss the issues with other brokers in choosing E&O insurance. Brokers and licensees should review their broker practice, and that's about it. So what we've done then is we've basically focused on the renewal process and paperwork that was necessary, elements of E&O insurance affecting you, and then some of the modifications and considerations to make. I wanted to make a great education offer before we go into our Q&A session. That offer is for $380 because we're basically going to credit the cost that you paid for this webinar towards the package that would normally you'd be looking at $429 for a 20-hour CE program, but we're going to be offering more than that on this special. It's going to include the E&O resource packages. In addition, 20 full hours of CE. This applies to all courses in Alaska. It does not apply to the Maui, although you can do a $100 upgrade for that. But you can get the full 20 hours of CE, and it does include the EDGE conference that we'll be having, the Asset Protection Cryptocurrency, in June here in Anchorage. Also, 2 years access to the real estate depository with all the forms, Excel spreadsheets, all kinds of marketing copy as well. In addition to that, you get a 6-month enhanced listing Alaska Yellow Pages. We had 3.2 million visitors last year. We're now currently in the launch of our Lower 48 platform. We're expecting 500 million visitors next year, so it just keeps growing. So you can be there where thousands of people are looking for real estate professionals. And we'll also get you an asset protection consultation with a leading law firm that we use to make sure that your assets are protected effectively. So the total value on this is $2,518, but you can save $2,138 simply by signing up today. You'll be able to see the link in the chat room that you can click on and link. In looking at some of the real estate commission's frequently asked questions, we'll cover those before we then move on to individual licensees' questions, which you can put into the chat box. So, do you need E&O insurance to renew your license? Yes, you've got to provide it. This certificate of liability insurance, this is the link to their page. By sending the Accord form titled Certificate of Liability Insurance to the Real Estate Commission, you can either email it to Sharon Walsh or Nancy Harris, you can fax it to them, or you can send it via slow mail. So they've got to get their hands on that. Both of the forms, Certificate of Liability Insurance and the Accord 25 forms, are included in your resource downloads that we're sending you. If I have E&O insurance through the master policy provider risk, do I need to send them proof of insurance? The answer is no. They're going to give you a list of those people that have already applied for them. It says, if I'm applying for initial real estate license, can I get E&O insurance before I receive my real estate license? The answer is yes, because the requirement requires that if a new licensee is going to get their insurance or get their license, they have to show that they've got E&O. So when you go to the Rice platform, it says that you don't have a license number yet. You can still get it. Of course, you got to pay. But in other cases, if you're using a carrier other than Rice, you may find that your insurance carrier is willing to do that as well. So you can check with them. So that's kind of it in terms of the subjects. You can click on the offer in the chat box to get the savings in order to get the additional classes and those additional resources. But we're going to go ahead and open it up to the question and answers that you have. You can go ahead and just start typing those questions into the chat box, and we'll stick around as long as is necessary in order to work through those questions that you have. Thanks a lot for attending, folks. We're going to be doing some additional emails. We've been sending out surveys. We're continuing to do that so we can keep people apprised of what's going on because we're running out of time to get this stuff renewed. We want to be able to give you information that you can use to make the process a little bit easier for you. Thanks for coming, everybody. And let's go to the questions and answer part of the program.